Hello everyone! In this video, we will present a case digest related to denial of taking the examinations. I and my partner Mary Jeremy Angeles will relay in detail the case we titled No Ticket, No Exam. Here are the primary details of the case. The petitioner, Christine Rhea M. Regino, who was assisted and represented by Armando Regino. The respondents, Pangasinan Colleges of Science and Technology, Rachel A. Gamurot, and Elisa Baladed. The case was properly filed with General Register Number 156109 on November 18, 2004, recorded by Panganiban J., the ponente during the hearing.
Here are the facts of the case. Christine Rhea M. Regino was a first-year computer science student at Pangasinan Colleges of Science and Technology, or PCST. Reared in a poor family, Regino went to college mainly through the financial support of her relatives. During the second semester of the school year 2001 to 2002, she enrolled in logic and statistics subjects under respondents Rachel A. Gamurot and Elisa Baladed, respectively as teachers. In February 2002, PCST held a fundraising campaign themed Rave Party and Dance Revolution, the proceeds of which were to go to the construction of the school's tennis and volleyball courts. Each student was required to pay for 2 tickets at the price of 100 pesos each. The project was allegedly implemented by recompensing students who purchased tickets with additional points in their test scores. Those who refused to pay were denied the opportunity to take the final examinations. Financially strapped and prohibited by her religion from attending dance parties and celebrations, Regino refused to pay for the tickets. On March 14 and March 15, 2002, the scheduled dates of the final examinations in logic and statistics, her teachers, respondents Rachel A. Gamurot and Elisa Baladed, allegedly disallowed her from taking the tests. Respondent Gamurot made her sit out of her logic class while her classmates were taking their examinations. The next day, Baladed, after announcing to the entire class that she was not permitting the petitioner and another student to take their statistics examinations for failing to pay for their tickets, allegedly rejected them from the classroom. Petitioner's pleas ostensibly went unheeded by Gamurot and Baladed, who unrelentingly defended their positions as compliance with PCST's policy. On April 25, 2002, the petitioner filed, as a pauper litigant, a complaint for damages against PCST, Gamurot, and Baladed. In her complaint, she prayed for 500,000 pesos as nominal damages, 500,000 pesos as moral damages, at least 1 million pesos as exemplary damages, and 250,000 pesos as actual damages, plus the cost of litigation and attorney's fees. On May 30, 2002, respondents filed a motion to dismiss on the ground of the petitioner's failure to exhaust administrative remedies. The respondents believed that the question raised involved the determination of the wisdom of an administrative policy of the PCST. Hence, the case should have been initiated before the proper administrative body, the Commission of Higher Education, or CHED. The petitioner argued that prior exhaustion of administrative remedies was unnecessary because her action was not administrative in nature, but one purely for damages arising from respondents' breach of the laws on human relations. On July 12, 2002, the RTC dismissed the complaint about lack of cause of action. The petitioner filed the present petition in the Supreme Court on pure questions of law, and the SC find the petition meritorious. November 18, 2004, the Supreme Court granted the petition to reverse the decision made by the Regional Trial Court.
Here are the education-related issues, the decisions made by the Supreme Court, and the rule of law as the basis of the decisions. The first issue: were the respondents guilty of breach of contract? The answer is yes. It was on record that Pangasinan Colleges of Science and Technology imposed the sale revenue-raising measure belatedly, in the middle of the semester. It exacted the dance party fee as a condition for the students taking the final examinations, and ultimately for its recognition of their ability to finish a course. But the court noted that the fee, however, was not part of the school student contract entered into at the start of the school year. Hence, it could not be unilaterally imposed to the prejudice of the enrollees. The decision was made according to the 1987 Constitution and the Education Act of 1982. According to the 1987 Constitution, Article 14, Section 5, Number 1, the state shall protect and promote the right of all citizens to quality education at all levels and shall take appropriate steps to make such declaration accessible to all. From the same section, number 3, it states that every student has a right to select a profession or course of study subject to fair, reasonable, and equitable admission and academic requirements. And according to Education Act of 1982, Batas Pambansa 232, Section 9. Section 9 is about the rights of students in school. In addition to other rights and subject to the limitations prescribed by law and regulations, students and pupils in all schools shall enjoy the following rights. Number 2, the right to freely choose their field of study subject to existing curricula and to continue their course therein up to graduation, except in cases of academic deficiency or violation of disciplinary regulations. The next issue is, were the respondents liable for tort? The court said yes. The Supreme Court made it clear that being unable to finish any of her subjects for the second semester of that school year and had to lag in her studies by a full year by reason only of their poverty, religious practice, or a low station in life, which inculcated upon the petitioner the feelings of guilt, disgrace, and unworthiness as a result of such punishment, she was allegedly unable to. The acts of the respondent supposedly caused her extreme humiliation, mental agony, and demoralization of unimaginable proportions, and the act violated the contract may also be a tort. According to the Civil Code Article 19, every person must, in the exercise of his rights and the performance of his duties, act with justice, give everyone his due, and observe honesty and good faith. From the Civil Code Article 21, states that any person who willfully cause loss or injury to another in a manner that is contrary to morals, good customs, or public policy shall compensate the latter for the damage. And lastly, from the Civil Code Article 26, Every person shall respect the dignity, personality, privacy, and the peace of mind of his neighbors and other persons. The following and similar acts, though they may not constitute a criminal offense, shall produce a cause of action for damages, prevention, and other relief. The third issue is, were the respondent's actions to deny the petitioner and other students from taking the exam because of not paying the tickets under the exercise of academic freedom? The court's answer is no. The Supreme Court had emphasized that once a school has, in the name of academic freedom, set its standards, these should be meticulously observed and should not be used to discriminate against certain students. After accepting them upon enrollment, the school cannot renege on its contractual obligation on grounds other than those made known to and accepted by students at the start of the school year. Based on the 1987 Constitution Article 14, Section 5, Number 2, academic freedom shall be enjoyed in all institutions of higher learning. And from the 1987 Constitution Article 14, Section 5, Number 3, every student has a right to select a profession or course of study subject to fair, reasonable, and equitable admission and academic requirements. The fourth and final issue was the principle of exhaustion of administrative remedies applies in a civil action exclusively for damages based on the violation of the human relation provisions of the Civil Code. To further emphasize the question, did the Commission on Higher Education, or CHED, have exclusive jurisdiction over actions for damages based upon the violation of the Civil Code provisions on human relations filed by a student against the school? The court's answer is no. Accordingly, administrative agencies are not courts. They are neither part of the judicial system, nor are they deemed judicial tribunals. Especially, the CHED does not have the power to award damages. Hence, the petitioner could not have commenced her case before the Commission. In support of the court's answer, it emphasized the powers and functions of the Commission. According to Section 8 of RA 7722, entitled An Act Creating the Commission on Higher Education, Appropriating Funds Therefore and for Other Purposes, enumerates the powers and functions of the Commission. The summary of Section 8 of RA 7722, the Commission on Higher Education is the Philippine government's agency in charge of promoting relevant and quality higher education, ensuring access to quality higher education, and guaranteeing and protecting academic freedom for continuing intellectual growth, the advancement of learning and research, development of responsible and effective leadership, education of high-level professionals, and enrichment of historical and cultural heritages. To simply say it, the Commission doesn't have jurisdiction over civil cases as it was not included in the provisions. Now here are the important things we learned from the case that we think we should live by. Looking into the accounts of the Bible, we can see that the Bible is rich in wisdom about God's love for people living in poverty and about our responsibility to help. We love the way Jesus showed us how to care for the poor and the oppressed. It is a major theme throughout the Bible that God cares for the poor. Our Lord clearly wants His people to look out for the economically impoverished. And that is why Jesus really emphasized over and over that we should love one another. We should love and offer abundant consideration to the people deprived of better living. Remember one of God's promises to those who give careful thought to the people in need. Jeremiah 7 verses 5 to 7, it says, "For if you truly amend your ways and your deeds, if you truly practice justice between a man and his neighbor, If you do not oppress the alien, the orphan, or the widow, and do not shed innocent blood in this place, nor walk after other gods to your own ruin, then I will let you dwell in this place, in the land that I gave you to your fathers, forever and ever. And we should not forget the advice of the wisest king, King Solomon. Proverbs 31 verse 9, it says, "Open your mouth, judge righteously, defend the rights of the poor and the needy." And lastly, from the writings of Ellen White, Welfare Ministry, Jesus associated himself with the poor. It has become fashionable to look down upon the poor, but Jesus, the Master, was poor, and he sympathizes with the poor, the discarded, the oppressed, and declares that every insult shown to them is as if shown to himself. I am more and more surprised as I see those who claim to be children of God possessing so little of the sympathy, tenderness, and love which actuated Christ. Remember, there is no great nor small in the sight of God. Everyone is equal. So let us remember to help each other for the benefit of humanity and for the glory of God. That's all for this presentation. We hope you learned something. Thank you for watching.